I was going to say Captain Kirk, but
John-Luc Picard, the haircut, the John-Luc
Senator
Picard.
Booker, I have an affinity for Star Trek as well. Maybe we should start a Star Trek caucus.
I agree.
Judge Koh, thank you for being here. Congratulations on your nomination, and congratulations to your family. I know they're probably all proud. I just want to go back briefly. I'm not going to read the statement that Senator Kennedy read. When I asked you about this in 2016, you said you completely disagree with that. I think one of the reasons why we go back 31 years and longer is the standard keeps moving here. We've gone back to high school yearbooks for what some teenager said or wrote in their yearbook as a basis for judging someone's qualifications as judge. I tend to disagree with it, but I do want to ask you a question that really an abstract, because when you read the statement, it does say that you need to disguise it. So when you answered me back in 2016 that you completely disagreed, can I be absolutely certain that you're still not disguising that bias? And maybe one way that you could put me at ease is maybe describe some case in abstract. I know you probably won't want to get into details where you may have had a certain sympathy, but you had to make a decision in the other direction. Have you ever had an experience like that as a judge?
When I preside over any case, my personal feelings are irrelevant. That's not my job. And I appreciate that you're taking your advice and consent role very seriously, and I understand that statement is disturbing. It's disturbing to me.
I think so.
So I think it's completely a fair question, but I completely disagree with it. And I think if you look at 3,250 written opinions and the thousands of issued rulings I made on the state court, having 500 cases a week, you can see that I have been fair and impartial. My judicial oath is so important to me, and I completely do my level best to be fair and impartial in every case and to try to get it right by limiting my decisions to the facts before me, limiting my rulings to the issues before me, and following precedent. Now, as I've said, I may not get it right all the time, but that's what I'm trying.
I want to get back to, I'm the ranking member, previously the chair of the Intellectual Property Subcommittee, so I do have to get back to Qualcomm. And as Senator Cotton said, it was characterized as a trailblazing application of antitrust laws and an improper excursion beyond the outer limits of the Sherman Act. So I think you said that you wrote a more than 200-page opinion.
I did 233 pages of factual findings and
that it was
credibility
largely, or that it was at least substantially influenced by the prior Motorola case. So
that's correct.
And that was Ninth Circuit precedent. So do you, looking back at their assessment of what is now a vacated opinion, do you agree with the Ninth Circuit's interpretation in the context of the Motorola case and in the context of your finding?
The Ninth Circuit decision is the controlling law, and that is what I'm going to apply.
But I mean, it's more a matter of, and I'm not an attorney, so
yes.
I don't know if I get you into a position where you can't answer the question based on other cases that may come before the court, but I'm looking more at more of a, I didn't think about it that way when I was writing my opinion, because they looked at the same thing. They looked at binding precedent, and then they looked at your ruling. And so I'm just trying to get a sense, did you learn from that and say if I'd really viewed it from that perspective, I would have ruled differently?
Personally, for me, antitrust is a really complex area of the law, and I certainly can see that there are different viewpoints. Yeah. The Ninth Circuit did not address this standard-setting body FRAND obligation directly. They just said the remedy should be in contract, or it should be in patent, and shouldn't be an antitrust law. Yeah. So they didn't actually address Microsoft v. Motorola head-on. They just said you need to go to other areas of law for remedy.
Let me just get back in my remaining time. Do you think worldwide injunctions on issues involving patents and patent license issues are appropriate?
The Supreme Court has said that injunctions at any point, preliminary or permanent, are an extraordinary remedy. And But the standard is, without undue burden on the defendant, you need to provide complete relief to the parties. And in antitrust law, there are a lot of once the government shows liability on the antitrust case, all of the presumptions go in favor of the government for the remedy. And in antitrust law for injunctions, you've got to basically disgorge the profits, you've got to stop the monopoly, you've got to prevent the monopoly from going forward. There are really very high bars to antitrust injunctions.
Yeah, I'm going to submit some questions for the record in the patent space, but I think that in the Ninth Circuit ruling they said, and I think this is important for our innovation economy, there's a difference between being anti-competitive and hyper-competitive. And I want to make sure that we're very clear on that distinction, because hyper-competitive in an increasingly threatening world, particularly with respect to nations like China, is exactly what we need to do to maintain our innovation edge today. But I will submit some other questions for the record. Thank you, and congratulations again to your family.
Thank you.
I'd just like to announce, since we have a second panel, that there are 4 senators, 2 Democrats, 2 Republicans, who've said they still are going to try to make it. Some have conflicts with other committees, and I want to give them the latitude and flexibility for that purpose. And one of the 4 is here now. Senator Cruz, you're recognized.
Thank you, Mr. Chairman.